My name is Brian Bartels, and I'm with Fraser Stryker. I'm going to delve into some of the details on the age 26 coverage. And on the face of it, this sounds like a very simple, easy thing to comply with. You have someone who's not 26, you provide dependent coverage, you have to give that person coverage. But as we're going to see as we start applying real-world facts to this new mandate, we find that it's actually fairly complicated and fairly difficult to comply with, especially when we add in state law on top of the federal mandate. So our client, CC, faces several legal mandates. First, they have the Patient Protection and Affordable Care Act as it was amended. And then on top of that, they have the federal regulations that implement the PPACA. On top of that, they have the Nebraska law that was implemented last year to provide for extended dependent coverage. And so we have three different sets of laws that our client, CC, is going to have to comply with. And as used throughout my presentation, adult child or adult children refers to someone who has not attained the age of 26 yet. So PPACA enacted an amendment to the Public Health Service Act. And so under the Public Health Service Act, or the PHSA, we now have Section 2714. Section 2714 provides that a group health plan that offers dependent coverage must continue offering the dependent coverage until the individual has reached the age of 26. This provision of the Public Health Service Act gets incorporated by reference into the Internal Revenue Code and also ERISA. So it's really found in three different places. There's parallel provisions with obviously different enforcement mechanisms because it's in three different places of federal law. Importantly, the PPACA and then the implementing regulations provide that if you're in a state that provides greater protection than the federal law provides, that state law is not preempted. And so that's why, as we're going to see in a few slides, our client CC will have to comply both with the federal mandate and then with Nebraska law down the road. And this mandate became effective for plan years beginning on or after September 23rd, 2010. So we're already in the effective period for this mandate. Now, the federal regulations were issued this spring to implement Section 2714. And the federal regulations provide fairly detailed guidance on what an employer or a plan sponsor must do to provide continued coverage for someone up until the age of 26. Now, one of the key mandates is that for adult children, you cannot define in your plan what a dependent is for purposes of eligibility based on basically any factor other than the relationship between the parent and child. So if you look at your plan document right now, you may have multiple factors here that say if you meet one of these factors, you're not eligible to participate in the plan. Now, the regulations are very clear that you cannot require financial dependency, the residency with the primary subscriber, student status, employment, or eligibility for other coverage. Those are all impermissible ways to define who is a dependent for purposes of your plan. Then on top of this, we have Nebraska law. This section 44-7,103 was implemented last year with the passage of LB 551, which was probably March or May of last year. And Nebraska law provides that a health benefit plan must provide continued coverage if the coverage for the child would otherwise terminate because the person ceases to be a dependent, ceases to be a full-time student, or attains the age that the plan says is the age on which you come off the coverage. And so depending on the circumstances under Nebraska law, that individual can actually stay on the plan until the age of 30. And there's several other factors that determine when the person then would go off the plan. It's the month that they attain the age of 30, the month that they marry, or they cease being a resident of Nebraska unless they meet a certain age requirement or are a student attending an outside state college or university. So theoretically, we could have someone who under the plan, like if the plan says you're no longer dependent until the age of 19, Nebraska law will kick in and say you theoretically could have coverage for that person up until the age of 30. So our client CC faces this challenge that they have a plan that provides for dependent coverage. So under the PPACA, they're going to have to continue providing coverage for that individual up until the age of 26. Now, CC wants to know how is there a way that they can maybe recoup some of the cost for having to implement this program and for administering it. So the first idea that CC has is to put in a new surcharge, $50 a month for each child between ages of 19 and 26. Now, the regulations are very clear that CC cannot impose this $50 surcharge. The preamble of the regulations gives us an example that you cannot impose a surcharge to provide continued adult-dependent coverage. And so if CC would implement this $50 a month surcharge, they'd be in violation of federal law. So the next idea that CC has is that they're going to limit or reduce benefits depending on the age of the child. So they amend their plan to say that any child up to the age 5 can go to the doctor 15 times a year. For a child between the ages of 5 and 18, they can only go to the doctor 9 times a year. And then between ages of 18 and 26, they're only going to pay for 3 doctor visits a year. Now again, this is going to violate the federal regulations that implement the PPACA, because the regulations again are very clear that you cannot vary the benefits that the plan provides based on the age of the child. And this probably violates another part of the PPACA that says that you can't impose, an annual or a lifetime benefit level. And because we're putting in, you can only go to the doctor, a certain number of times a year, you'd probably also be in violation of that provision. There's a question and kind of a debate that's going on right now about whether or not under the PPAC and the regulations, if you don't state a dollar amount for annual limits and lifetime limits, but you say you can only go to the doctor, 5 times a year, you can only, use an ambulance 3 times a year, whether or not that would actually be violating the annual and the lifetime limit cap. And we're still waiting for more definitive guidance from Department of Labor, IRS, and HHS to determine whether or not that type of limit would be allowable. It seems that that's a little too easy to get out of the lifetime and annual limits by instead of stating it in a dollar amount, stating it in a visit amount, because at the end of the day, the net effect is the same. You're still putting a limit on benefits. So at this point, we're advising, don't try to be, creative by doing this type of benefit, especially with dependents, because it's very clear you can't vary the benefits that are provided to an adult dependent based on their age. Now, the third change that CC proposes to its plan is to say that they're only going to cover adult children if they are not married. And again, this violates the PPACA and the regulations that the plan cannot condition adult coverage based on whether or not the person is married. So if they're married or unmarried, the plan still has to offer them coverage. Next change is that CC provides that it's only going to enroll adult children who are not eligible to enroll in employer-sponsored health plan. Now, this potentially is permitted depending on whether or not CC is a grandfathered plan or a non-grandfathered plan, and Dan just discussed kind of the contours of what it means to be a grandfathered plan. One of the special rules in the regulations is this almost transitional rule for grandfathered plans. So if CC's plan is a grandfathered plan between September 23rd in 2010 and January 1st of 2014, CC is allowed to say that if the adult child or the adult dependent has coverage under an eligible employer-sponsored health plan, that it does not have to offer coverage under its plan. But if CC is not a grandfathered plan, then it cannot put in this limitation. It has to provide coverage to all adult children. And this creates some very interesting verification issues. Primarily, how do you know whether or not the adult child is eligible for employer-sponsored health plan? How are you going to get that information, or how is CC going to get that information from either the participant or the adult child to determine whether or not they have this coverage? Then another verification issue that arises with this grandfathered status is making sure that the plan that is being offered by the dependent's employer is actually an eligible employer-sponsored health plan. That term has a very specific meaning in Section 5000A of the Internal Revenue Code. And so it's not just any employer coverage that will satisfy that requirement to allow a grandfathered plan not to cover this adult child. It has to be eligible employer-sponsored health plan that meets the definition of Section 5000A of the Internal Revenue Code that would allow CC to keep the adult child off of their health plan. So, if you're a grandfathered plan and you're trying to implement this, it's very important to get documentation verification that the adult child does have this other sponsored care from their employer, and more importantly, that employer's coverage meets the definition in the Internal Revenue Code. Both of those two pieces of information are going to be very important. Now, CC has even more problems. CC employs an individual named Rhonda, and Rhonda has a child named Tom who is currently covered under CC's plan, and Tom turns 24 on November 1st of 2010. So as their plan is currently written, Tom will drop off coverage as of November 1st. And we're going to assume that CC has a calendar year plan, so January 1st to December 31st. So what is going to happen to Tom on January 1st of 2011? Well, CC's plan is going to have to cover Tom even if he drops off after November 1st of 2010. And we can assume, let's say for this instance, that the plan year, that they're not having to cover him right now or as of November 1st. So on January 1st, the federal regulations provide that there's a transition rule. So if someone that was previously a dependent covered under CC's plan drops off because they meet or that they fail to meet the age requirement for a dependent, come January 1st of 2011, when CC has their new plan year, they have to provide a 30-day window for Tom to come back onto their plan. And to accomplish that task, CC is also going to have to issue a notice either to Rhonda, who's the plan participant, or to Tom directly to provide both of them the information that because of the PPACA requirements, Tom can now come back on to CC's plan and have coverage under that plan. And the federal regulations provide fairly detailed information about how the notice must be written, when the notice must be given, and what the time period is for allowing Tom to come back onto the plan and receive coverage. So let's move forward a few years and say that Tom turns 26, and he's going to turn 26 on November 1st of 2012. Now, Tom will lose coverage under CC's plan once he turns 26. So under the regulations, the last day Tom will be covered by CC's plan is October 31st of 2012. Now, does CC still have an obligation after October 31st of 2012 to provide some coverage under its health plan to Tom? Now, there's a potential obligation for CC to continue providing Tom with coverage under its plan based on Nebraska law. Now, as we discussed earlier, the federal law, the PPACA, and the federal regulations provide that the PPACA does not preempt state law to the extent that state law provides more favorable coverage to adult dependents. And in Nebraska, in this situation, Nebraska law would provide Tom and Rhonda a more protection than federal law would, because Nebraska law theoretically allows an individual to stay on their parents' coverage up until the age of 30. So there's several key pieces of information that we'll need to know to determine whether or not CC is going to have to continue covering Tom on its plan. The first thing we'd want to know is whether or not Tom is married. Under the Nebraska law that we discussed earlier, the plan must continue covering Tom until the earliest of one of these things happening. One of those events happening is he's married. So if he's married, then then CC's plan only has to provide coverage until the end of the month in which he's married. So we'd want to know, is Tom married? Next thing we need to know is whether or not Tom is a resident, because under Nebraska law, if he's no longer a resident, CC's plan doesn't have to cover him or can stop covering him at the end of the month that he ceases to be a Nebraska resident unless he's under the age of 19 or he's attending an out-of-state college. So we want to make sure that we're finding out whether or not Tom lives in Nebraska or does he have student status at a college or university outside of the state of Nebraska. Additionally, we want to know whether or not Tom has coverage under another plan, because there's a special rule under the Nebraska law that provides that the employer's plan or the parent's employer's plan does not have to provide coverage if coverage is available under another plan for the adult child. So there's a number of questions that we'd want to work through and ask Rhonda and Tom to determine whether or not CC's plan would have to continue covering Tom after age 26 and before the age of 30. So we have the interplay between federal law and state law working to provide, a fairly long period of coverage potentially for Tom. And yes, we have some more complications to make CC's life even more difficult. Now let's say that Tom is 24 and is currently covered under CC's plan. And then Tom is also covered under his employer's more generous plan. So technically he's being covered by two different plans. Now the first question, is this double coverage permitted? We've had several questions arise whether or not this type of situation can occur. Now the federal regulations that implement the PPACA don't discuss this. And so it's assumed that if someone wants to have both coverage, yes, they're able to have both coverage. So then, let's say that Tom is seriously injured. He has a catastrophic accident and all of a sudden has $150,000 in medical bills. Now, which plan is going to pay those bills? Is it going to be CC's plan, or is it going to be Tom's other employer's plan? And that question becomes fairly difficult to answer because we need to know what do the coordination of benefit rules in both CC's plan and Tom's employer's plan say about which plan is primarily liable and secondarily liable. So we would want to see the actual insurance policy and materials that have been provided to Tom under both plans to try to figure out which plan is going to be primary and secondary. And then if that doesn't work, there are Nebraska regulations that have been implemented under the insurance regulations to determine which plan is primarily liable and which plan is secondarily liable. So we want to look at those regulations as well to see which plan is going to initially foot the bill for Tom's $150,000 expenses. Then, of course, if that doesn't work, if for some reason the regulations don't cover one or more of these plans, we might have to resort to litigation to see which plan is ultimately liable to pay for the primary and the secondary coverage for Tom's injuries. So there's a number of potential issues to think about if someone is having more than one plan cover their health and their potential injuries. So we've developed a short action plan for things that CC needs to do going forward to start complying with the dependent coverage rules. First, it needs to review its plan document. As we saw at the very beginning in the fact scenario, right now, CC's plan provides that an adult child ceases to be a dependent at age 19. Well, that plan probably isn't in compliance with Nebraska law because it's not incorporating what was LB 551. It's not incorporating those extended dependent care coverage requirements, and it also hasn't yet been amended for the PPACA requirements and the requirements under the regulations. So we want to review the plan document and amend it to conform both with the Nebraska law and the federal mandates. And along with that, we'd want to eliminate those factors that we first discussed that cannot be used to determine whether or not a child is an eligible dependent. So things like, student status, whether or not they are financially dependent on their parent or the primary subscriber, things like that we'd want to look for in the plan document and remove so that it is compliant with the federal regulations. Now, another thing CC might want to do is consider dropping coverage, completely for dependents. It has that choice. It does not have to cover dependents, theoretically. The problem is whether or not they're already within what their plan year is. If they're already, if their plan year is after September 23rd, 2010, and we haven't surpassed that mark yet up until today's date, they might be able to eliminate the dependent coverage without any grandfathered problems, or they might be able to eliminate it without actually violating the law where they had the dependent coverage and now they're getting rid of it. So we want to make sure that we're following some timing rules to make sure we're not eliminating a benefit that the dependents are already entitled to. Now, additionally, assuming that CC wants to keep the dependent children on, we need to prepare notices to adult children who may have gone off the plan already and who can come back on at the new plan year for CC's plan year. So we want to consult the federal regulations and incorporate the language that has been provided in the regulations to notify both the plan participants and potential adult children that they can come back on the plan and have extended dependent coverage. And finally, we need to be prepared for very unique situations. We've seen already some very interesting situations where, depending on the age of the child, the grandfathered status of the plan, and whether or not they're in Nebraska and the child is in Nebraska, all these different factors coming together to to create some very challenging situations where we have to look at federal law and then state law to see whether or not coverage is being provided and what charges can be made for that coverage. So we just always need to be prepared that some very unique situations are going to come up that will probably require the use of counsel. And so it's better to kind of ask your employee benefits counsel ahead of time before making a decision, because that can save you, potential problems down the road in this very challenging and unique situation. With that, I'm going to turn it over to Tony.